Welcome back to the deep dive. And I have to be honest with you, when I first looked at the topic for today, I kind of wanted to run for the hills.
I can imagine.
I've got a stack of documents here that includes legal guides, some lecture slides from Virginia Tech, these really dense blog posts from law firms, and transcripts from patent attorneys.
Yeah,
It looks like the kind of reading material you'd use to, cure insomnia.
it certainly has that reputation. But if you look past the jargon, this is actually, it's kind of the operating system of the modern world.
The operating system, I like that. That is
Hmm.
exactly what we are going to unpack.
Right.
We are talking about intellectual property, or IP.
Mm.
And our mission isn't just to define terms so you can, pass a bar exam.
No, not
We,
right.
we want to turn this stack of paperwork into a survival guide.
Mm.
We need to figure out what you own, what you can own, and frankly, how to avoid getting sued.
Or how to protect your own $1 million idea.
Yeah.
Because the lines between what's yours and what's everyone else's are getting blurrier by the minute, especially with the technology we have today.
Okay, so let's start at ground zero. When we say intellectual property, how is that different from, say, owning a house
Yeah.
or a car? Because I can hold a set of car keys. I can't really hold a concept.
And that's the fundamental distinction the sources make right out of the gate. You have real property, that's your land, your house, your physical stuff.
Okay.
Then you have intellectual property, which are, well, inventions of the mind. It's intangible.
So if I buy a book, I own the physical paper and ink. That's my real property.
Correct. You own that specific copy. You can burn it, sell it, use it as a doorstop, whatever.
But I don't own the story itself.
Exactly. You do not own the story. You don't own the right to print 1 million copies of it and sell them. That right, the copyright, that is the property.
Okay, that makes sense. But this gets complicated fast because there isn't just one type of IP. The sources outline 4 main pillars.
Right. And if you're listening to this and you want to kind of organize your mental shelf, these are the 4 big buckets. You've
Yeah.
got trade secrets, trademarks, patents, and copyrights.
Let's start with the one that feels the most, cinematic. Trade secrets.
Secret sauce.
Literally, the sources obviously mention the formula for Coca-Cola, the recipe for KFC. But let's dig a little deeper than just listing them. Why is a trade secret a specific legal thing? Why isn't it just, keeping a secret?
That is a great question. Legally, a trade secret is information that has economic value, specifically because it isn't generally known.
Okay.
If everyone knew it, the value would just poof, drop to zero.
Give me a non-food example.
Okay, let's look at the Zildjian Symbol Company. This is in the source material. They have been making symbols since 1623.
1623?
Yes, 1623. And the specific process of treating the bronze, the metallurgy, the way they heat it and roll it, that's a trade secret. It gives them a unique sound that competitors just haven't been able to perfectly replicate for 4 centuries.
So how do you actually protect that? Do you just pinky swear your employees to secrecy?
You have to do a lot more than that. The legal standard is that you must take reasonable steps to keep it secret. And this is where a lot of businesses mess up.
Reasonable steps being?
Things like non-disclosure agreements, NDAs, password protection, restricted access to the factory floor, maybe even splitting up the process so no single employee knows the whole recipe.
There was a counterexample in the text that made me laugh. It said, you can't claim a trade secret if you have a manufacturing process running right in front of a window where people walk by.
Exactly. If I can walk down the sidewalk and literally see how you make your widgets, you have lost your trade secret protection. You can't ask the law to protect a secret that you yourself didn't even bother to hide.
So here is the strategic question, though. If you invent something amazing, like that symbol formula, you have a choice. You can keep it a trade secret, or you can patent it. Why would you choose one over the other?
That is the $1 million strategic decision. Think about it. A patent, it gives you a monopoly, but only for a limited time, usually 20. After that, it's a free-for-all. Everyone can use your invention.
Ah,
A trade secret, well, it can last forever. As long as you can keep the secret, you have the monopoly. Coke has held their secret for over a century. If they had patented the formula in 1886, anyone could make generic Coke by 1906.
oh, wow. I never thought about it that way. So the trade secret is high risk because if someone figures it out, you're done. But it's also high reward because it doesn't expire.
Precisely. Reverse engineering is the enemy of the trade secret. If I can buy your product, take it apart, and figure out how it works, your trade secret is gone. You have no legal recourse.
Okay, so that's the world of secrets.
Yeah.
Let's flip the script to the world of being loud and public. Trademarks.
Yes. Trademarks are pretty much the opposite of secrets. They are all about shouting, "This is mine."
I feel like there's a massive misconception here. I hear people say things like, I need to patent my brand name, or I need to copyright my slogan.
And lawyers cringe every single time they hear that. You don't patent name, you trademark it.
So what is the actual job of a trademark? What's it for?
Source identification. That is the phrase to memorize. A trademark isn't just about you owning a cool word. It's about protecting the consumer. It tells the buyer who made the product.
So when I see the golden arches,
You know exactly what that burger's going to taste like. You know the quality, the price point, the sanitation standards. The trademark distinguishes those goods from just some random burger stand on the corner.
here's a scenario that I think trips people up, especially now in the internet age. Let's say I have a great idea for a shoe company. I go to GoDaddy and I buy superfastshoes.com. I own the domain. Does that mean I own the trademark for Superfast Shoes?
Absolutely not. And this gets people into so much trouble all the time.
Walk me through why.
Well, think of a domain name as just a street address. It's just directions to a digital location.
Okay.
A trademark is the sign above the store. Just because you rented the building at 100 Main Street doesn't mean you own the rights to the business name Main Street Hardware.
So if I buy that domain, but Nike already has a line of shoes called Superfast, I'm in trouble.
You could be, yeah. If you start selling shoes on that site, Nike could come after you for trademark infringement because you are causing what's called likelihood of confusion. You're using a name that makes people think your shoes are their shoes.
That makes perfect sense. It's
Yeah.
about not tricking the customer.
Exactly. And trademarks aren't just words. The
Mhm.
sources talk about trade dress, which is, it's fascinating. It's the visual vibe of a product.
The Coke bottle example is the classic one here.
It is, the contour bottle. Even if I peeled the label off, painted it black, and handed it to you in the dark, you would feel those ridges and that shape, and you'd say, this is a Coke.
Right.
That shape serves as a source identifier, so it's a trademark.
Okay, let's move to the heavyweight division, the one that protects the actual inventions.
Patents.
This is where we get into the utility of things. Patents protect new and useful inventions, processes, or machines.
Useful being the key word. We aren't talking about art here. We are talking about functionality. Correct. A new type of engine, a pharmaceutical drug, a method for manufacturing silicon chips. This is the quid pro quo deal we make with the government.
Quid pro quo.
Yes, the government says, look, if you tell us exactly how your invention works, if you publish the blueprints so all of society can learn from it, we will give you a 20-year monopoly where no one else can make it.
So you're trading secrecy for exclusivity.
Exactly. But there is a trap here that destroys so many inventors before they even start. It's called prior art.
I saw this in the lecture slides. It sounds like something from an art history class, but it sounds terrifying for inventors.
It really is. To get a patent, your idea has to be new, and the patent office chats what's called prior art, which is basically everything that has ever been publicly disclosed in human history.
And when we say everything, we really mean everything.
We do. Previous patents, sure, but also a scientific paper, a magazine article, a blog post from 2005, a YouTube video with 10 views.
Seriously.
Seriously, if anyone has described your invention before anywhere, you cannot patent it.
Okay, but here is the nightmare scenario the sources hint at. What if I am the one who talked about it? Let's say I invent a new type of coffee maker. I'm so excited that I write a blog post about it and put a video on TikTok showing how it works. 6 months later, I go to file a patent.
In many parts of the world, you have just destroyed your own patent rights.
Because I created prior art against myself.
Exactly. You made the information public. It is no longer new. The U.S. has a small grace period, but generally speaking, if you disclose it before you file, you are shooting yourself in the foot.
That is wild. So
Yeah.
the rule is, file first, brag later.
Always. And there is another myth about patents I want to bust, which came up in the Patents Demystified transcript. It's the expired patent myth.
Oh, right. The idea that if a patent from, 1920 has expired, I can just grab that idea and patent it myself.
Right. People think, oh, it's free real estate. But no. An expired patent is still a public disclosure. It's still prior art. It proves the idea isn't new.
So the idea is in the public domain, meaning anyone can use it, but no one can lock it down again.
Exactly. You can build that 1920s engine, but you can't stop your neighbor from building one too.
Okay, we've covered secrets, brands, and inventions. That leaves the fourth pillar, copyright.
Copyright is for original creative expressions. This is for the artists, the writers, the coders, books, music, movies, software code.
The key word there being expression. I can't copyright an idea, can I?
Correct. You cannot copyright the idea of a romance on a sinking ship. But James Cameron owns the copyright to the specific dialogue, the scenes, the execution of the movie Titanic.
This brings us to the biggest battleground on the internet: fair use. Everyone seems to think they know what this means, but the sources suggest it's way more complicated than just saying, oh, I gave credit, so it's okay.
I give credit is not a legal defense at all. Fair use is a doctrine that allows you to use copyrighted material without permission in certain contexts, like criticism, news reporting, or teaching.
But it's not a blank check.
No. Courts look at 4 factors and they balance them. Factor 1. What is the purpose? Is it commercial or is it educational? Factor 2. Is the original work factual or creative? Factor 3. How much did you take? A tiny snippet or the whole thing?
And the fourth factor, which the sources say is often the most important,
Yeah.
the effect on the market.
Right. Does your use replace the need for the original?
Let's apply this to a modern example to see if it holds up. Let's talk about those reaction videos on YouTube. I play a whole pop song, and I sit there nodding my head, and maybe I say cool once or twice. Is that fair use?
Well, let's run it through the factors. Purpose. You're likely monetizing the video, so that's commercial. Amount. You use the whole song.
Oh.
Market effect. This is the killer. If I can listen to the song for free on your channel, why would I buy it or stream it from the artist?
So I'm likely infringing.
Very likely.
Mm.
But if you pause the song every 10 seconds to analyze the chord structure and discuss the lyrics, that leans much more heavily toward criticism and education. That's transformative. You aren't just replacing the song, you are adding something new.
I see. It's about whether you are a substitute or a supplement.
That's a great way to put it.
Now, we've treated these 4 pillars, trade secrets, trademarks, patents, copyrights, as separate buckets. But the real world is messy. The sources have this section called the intersection. And I want to slow down here, because this is where the aha moment really happens.
This is my favorite part. The Rolls-Royce example from the Cowan text is just perfect for this.
the flying ladyhood ornament.
Right. Picture that little silver statue on the front of the car. What is it?
Well, first off, it tells me the car is a Rolls Royce.
Exactly. So it functions as a trademark. It identifies the source. But what else is it?
It's a statue. It's art.
So it have copyright protection as a sculpture. And finally, the specific industrial design of that ornament.
A design patent.
Bingo. 1 object, 3 layers of IP protection.
Let's try one more, just to lock this in. The chair example. Let's visualize a high-end ergonomic office chair.
Okay. Look at the lever under the seat that adjusts the height using compressed gas. The mechanism of how that works.
That's a utility patent. It's a useful invention.
Right. Now, look at the specific groovy curve of the armrest. It doesn't make the chair work any better, but it looks cool.
That's a design patent.
Yes. Now, imagine there's a fabric pattern on the seat, a little drawing of flowers or something.
That's a creative expression. So, copyright,
And stamped on the back of the chair is the company logo.
trademark.
You got it. So when you look at a product, you aren't just seeing a chair, you are seeing a bundle of intellectual property rights just stacked on top of each other.
That is fascinating. It's like seeing the code in the Matrix. Once you see it, you can't unsee it.
It really is.
Now, we have to talk about the elephant in the room. Or maybe the robot in the room. Emerging technologies. The sources, specifically the emerging technologies slides and the Copyright Alliance notes, they highlight this massive tension here. We have AI models that can generate art, text, code, but they have to learn from somewhere.
This is the input problem. To train an AI like ChatGPT or Midjourney, you have to feed it billions of data points, books, articles, paintings, music that were created by humans and are protected by copyright.
And the companies usually just scrape this from the internet without asking anyone.
Right. And here's the core debate. The AI companies argue that this is fair use. They say the AI is just reading the internet to learn patterns, just like a student reads a library of books to learn how to write.
A student doesn't pay the author every time they write an essay inspired by a book.
Exactly. They argue it's transformative. They aren't copying the books, they're learning the styles and facts contained in them.
But the artists and authors see it very differently.
Oh, very differently. They argue that this isn't reading, it's copying. They say the AI is ingesting their work to build a commercial product that directly competes with them. If an AI can create a Stephen King-style novel in seconds because it ingested all of Stephen King's books,
Then you're back to factor 4, the effect on the market. Why buy the new Stephen King when the bot can write one for you?
exactly. And the sources note that there is currently no clear answer. The courts are trying to figure this out right now. We are literally watching the law be rewritten in real time.
There's also a mention of the DMCA, the Digital Millennium Copyright Act, and technology protection measures. This feels like another layer of armor on top of everything.
It is. This is Section 1201. It basically says, it is illegal to break a digital lock.
Like the encryption on a DVD or a password on a software file.
Right. Even if you have a fair use right to use the content, say for a film class, you might not have the right to hack the encryption to get to it. So the code itself acts as a second layer of law.
So we have trade secrets, trademarks, patents, copyrights, and now digital locks. It feels like we are surrounding ideas with more and more barbed wire.
It can feel that way. But the goal, in theory, is to incentivize creation. If you couldn't own your work, why would you spend 10 years writing that novel or developing that medicine?
That brings me to a story from the sources that I think beautifully bridges this gap between Hollywood star and hardcore inventor, Hedy Lamarr.
Oh, I love this story. It's the perfect example to close on.
Most people know her as this glamorous 1940s actress, the face of Golden Age cinema.
But during World War II, she wasn't just reading scripts. She was worried about Allied torpedoes being jammed by the Nazis. So along with a composer named George Antheil, she invented a frequency-hopping spread spectrum technology.
Which is a mouthful.
It is. Basically, it made the radio signal hop around so it couldn't be jammed. She got a patent for it. Patent number 2,292,387. That concept is the foundational technology for Wi-Fi, Bluetooth, and GPS. The woman who was famous for her face, her copyrightable image, if you will, gave us the utility patent that runs our phones.
It just shows that innovation comes from the most unexpected places, and these IP categories can overlap in the same human being.
Absolutely. And it leaves us with a provocative thought that the sources touch on. We draw these lines, patents, copyrights, to encourage innovation. We want the Hedy Lamarrs of the world to invent.
Right.
But as we enter the age of AI, where machines can invent and create at lightning speed, are these old laws still doing their job? Or are they starting to stifle the very progress they are meant to protect?
That is the big question. If an AI invents the cure for cancer, who owns the patent?
Yeah.
The person who wrote the code, the person who turned it on, or nobody?
And if nobody owns it, will anyone spend the money to actually develop it?
That is a headache for another day.
Wow.
But for now, I think we've successfully navigated the roadmap. We know the difference between the secret sauce, the golden arches, the mousetrap, and the novel.
I think we've earned our badge in IP literacy.
Well, thank you for guiding us through this legal jungle.
My pleasure.
And to everyone listening, whether you are inventing the next big thing or just trying to name your shoe company, remember to check those factory windows.
Yeah.
You never know who's watching. We'll see you on the next Deep Dive.